right, we are here with Martin Hoffman of the 68th District Court, our distinguished jurist and a dear friend of mine. Martin is a wonderful advocate, both on and off the bench. He is dearly loved in the Dallas community for all of his efforts in trying to participate and be a part of all of the different constituents that make up the residents of this county. He's beloved by many for his advocacy and letting people try their cases and receive fair justice in his courts. So I'm very excited to have him for our very first guest on DTLA's new program, Here Comes the Judge, Best Courtroom Practices for Dallas Judges. Woo! Well, Judge, why don't you introduce yourself real quick, and then I will start with the hard-hitting questions.
All right. Well, my name is Martin Hoffman. I'm the judge of the 68th District Court for the last 18 years. I just got reelected to my 5th term. I love what I do. Prior to being a judge, I had served 13 years as a civil litigator, primarily in plaintiff's personal injury, but I did a few other things as well. I'm a strong believer in the civil justice system and the right to a civil jury trial, and always happy to help different bar organizations, including the DTLA, out when it comes to this type of thing. And hopefully we're going to provide some good information for your members on how to practice a little better in the state courts in Dallas County, and specifically the 68th.
All right. Well, I will jump right in then. All right. So what things do you see the best lawyers doing in your court?
I mean, obviously, the best lawyers do a variety of things. The number one thing, obviously, for civil litigation is that you have to be prepared. This is unlike maybe some other types of law where you can come in and shoot from the hip. The trial is the end of a long process, and you have to make sure that every step along the way you've done what you need to do to be able to get to that end point. But some of the most effective things I've seen from trial lawyers in my court is being able to use all the different avenues of persuasion that are available now. And what do I mean by that? I think a good litigator knows how to use the AV equipment, but also knows how to use old-fashioned forms of persuasion like flip charts and blow-ups and models and diagrams, to use all different forms of persuasion, because with modern juries, they have a short attention span, and you want to make sure that you're using every single method that is available to persuade. And I've seen attorneys that are too beholden to the AV equipment, and others that are too afraid of it. And being able to use the AV equipment, I think, is a critical part of the process, and being able to use technology is a critical part of the process, but it shouldn't be the whole part of the process. And obviously, integrity makes a difference. And I think jurors can sense when you believe in your case, that you brought a case in good faith. And judges do too. We have long memories, and I see great lawyers, and usually great lawyers do great things in every case. And so being consistent, I think, is also very, very important.
Oh, that's great. To follow up a little bit on the AV, what are your practices? Is that something that, if you've got someone that's got a big hearing or a trial coming up, that they could come in and test out the equipment? What kind of practices do you have with that?
So most people hopefully know in the DTLA, we just went through a major upgrade in our AV equipment. And the AV equipment has, in some ways, is very similar to what we had before. It's just better, it's faster, it's clear, it's more up to date, but it's also much more friendly for remote hearings. The ability to do hybrid hearings or witnesses remotely is, I think, vastly better than it was with the old equipment. And so I encourage people to understand how to use the AV equipment. I think if there's any area of litigators that I see in my court regularly that are least likely to use the AV equipment, it's unfortunately plaintiffs' lawyers. And I think the ones who could benefit it from the most are actually plaintiffs' lawyers. And so I encourage everybody who's watching this in the DTLA to not be afraid of the AV equipment and to really learn how to use it. We just did a seminar today for the DTLA. We have another one coming up for the business litigation section for the Dallas Bar, and we have some other coming up where we're training people how to use it. This new equipment is a little more difficult to use fully, especially the Zoom component of it or the remote component of it. But once you figure out how to use it, once your people in your office can use it, I think it can give you a big advantage in being able to persuade and be able to call witnesses effectively if you need to call them remotely. And so, but also just the equipment as a whole can be very effective and as an avenue for persuasion. And so, I'd strongly recommend people try the equipment out. They're always welcome to come in schedule a time to come in at 68th to use it and to know how to use it. But it's not something I would try to learn as you show up that morning and when the jury is there and say, I want to turn on the equipment and start using it. You can do that for the document camera, which is, the most old-fashioned portion of it. There's a lot of other features you can use to be more effective if you know how to use the equipment.
Okay, so I mean, the big thing is y'all got some good new equipment in, but it does take a bit of understanding it. But the ability there is just much higher than what it was in the past.
It's the part that you probably really need to prepare for is if you're going to have a remote witness, because that portion of it is not intuitive. You really have to learn how to do it. That was something that was kind of interesting. It took me a couple of times to be trained to realize, okay, now I finally get how this is supposed to work. The rest of it is pretty similar to what we had there before, and I think most people will be pretty comfortable with it if they knew how to use the old equipment. It's using the remote feature that really requires, I think, some additional training and understanding.
Okay. Well, all right, let's move on to some other stuff here. Burning question is what are some of your biggest pet peeves with lawyers in your court?
I mean, one thing that I've seen a lot of, and I don't know that it's really a pet peeve, but I think it affects plaintiffs' lawyers. And I, when I was I used to be a plaintiffs' lawyer. I never really got how busy the trial courts were in Dallas County, that had just the sheer number of cases. And so one of the things I've noticed that is, I don't know why this is happening more lately, is people are not, and this may seem like kind of a minor issue, but people are not really being careful on the final documents they're filing with the court. And what do I mean by that? For example, filing a non-suit, but not making clear if it's a final non-suit for all parties or just for some parties, or calling something that's supposed to be a partial non-suit, but include language that indicates it's a final order. Really be careful, because we have constantly rotating clerks in the clerk's office. We have coordinators. We have a huge volume of cases. Make sure that you're really paying attention to how you draft that non-suit or that agreed judgment or agreed partial judgment, and make it very, very clear to the clerks and to the court and to the coordinator what exactly are you trying to do. Should this case remain open or should this case continue? And, I do my best to try to check that, but with the sheer volume we have, sometimes it's hard to know, is this a final order? Is this not a final order? That can make a big difference on whether or not your case accidentally gets closed or not, especially if it has inconsistent language in it. So that's something I've seen a lot lately that is concerning. And I think people just need to they may not think about it because they're thinking of their next case. I used to do a volume practice, so I get you're trying to go to case to case to case, but it can have a profound impact if you don't do it correctly and something accidentally gets closed and then you miss deadlines. You're not able to bring claims you should be able to bring.
Oh yeah, especially once the court's power over the subject matter is gone, that can be a real big problem. Okay, well, I think yeah.
It just can cause problems that don't need to happen.
Yeah, that makes perfect sense. So just clarity in especially dispositive motions that are going to wrap the thing up.
Dispositive orders, really. Dispositive
Positive orders.
What does this
Okay.
order really mean? Is it a final or is it a partial, or what exactly are you trying to do here? And I see a lot of inconsistency, and because people aren't paying attention to that. That's something I've seen a lot of. The other thing is just, from the plaintiff lawyers, I think to be successful, we've seen a lot of big plaintiffs' verdicts in the last year in my court, and successful lawyers on the plaintiff side, I think, are going to be ones who are really passionate about what they're doing and seem to really care. I've seen some lawyers who, I don't know why, but sometimes they don't seem as passionate about it. They don't seem to care as much. They don't do as well. And so really be passionate about what you're doing. If you're presenting to a jury, you need to care. You need to be the person in the room that cares the most about this case, and you need to be able to convey that to a jury. I think that's, I don't know if it's really a pet peeve, but it's kind of a piece of advice that I would give, that I've seen some plaintiffs' lawyers. It just kind of surprises me that they don't seem like they care that much sometimes when they're presenting to a jury, and that definitely jurors pick up on that, and the court picks up on that.
Yeah, you come in like a dead fish. It's not necessarily rousing the hearts and minds of the people.
No one. Yes, exactly. And I get it. This is a stressful job. It's hard to keep that level of enthusiasm, but it's important if you're going to be successful.
No, for sure. Well, okay. I know one thing that is of interest to a lot of people, and I know it's not much of an issue in your court, but what's the best way to get hearings in your court?
So for general hearings, so let me just kind of talk about how we do hearings in my court, because every court is different. So we have on Monday, this is based on a lot of work I've been kind of doing over the years since COVID. On Monday, we have an entirely remote docket. So every hearing is remote. On Friday, we have what I call a whatever you want docket. So if you want to be in person, you can be in person. If you want to be remote, you can be remote. If you want your witnesses remote, you can have your witnesses remote. You want your witnesses in person. So it's completely open. So if you really feel it's important, and I really think in most cases it doesn't, especially on the PI side, if you're talking about a motion and compel or whatever, I don't really care if it's in person or remote. If you cared, then really want it to be in person, do it on a Friday. But just understand that when you're scheduling hearings, for general run-of-the-mill hearings that don't have any type of time sensitivity, just contact the clerk's office and ask for a hearing date. They'll put you on a Monday or Friday. If there truly is an emergency, and really be careful about claiming something as an emergency. I've done hearings on, an hour notice or 2 hour notice if something's truly an emergency. I'll do it remotely. I'll do it in person. However it's done. If there truly is an emergency, obviously contact my court coordinator, Rhonda Pinson, and she will reach out to me. Also email her, and I can set up an emergency hearing. Or even if you have a hearing that, you need, if you contact the clerks and you feel like you need to get it set right away, and they're giving you dates that are too far off, contact Rhonda. And if I can fit it in and I feel it's an emergency, I'll find a way to fit it in. But generally, contact the clerks. Emergency, contact the coordinator.
Are there categories of hearings or types of hearings that you would say requesting an associate judge is appropriate in your court?
Yeah, let me just kind of give an update about that. So as many of you know, we lost our associate judges recently, which is very unfortunate. We have hired one new associate judge at this moment. This is at January 31st. Her name is Judge Craig. I feel very excited about her. She is, I think, going to do an excellent job and hopefully will be with us for a long time. She is not currently assigned to my court, although when she has availability, she has covered hearings for me. I would think generally for associate judges, don't be afraid of them. Some people seem to be afraid or don't think they wanted to use associate judges. And so I understand for some hearings, it may be important to be in front of a district judge. But if you get assigned to associate judge, you can't object to it legally. It's not like a visiting judge. You can appeal their orders, most of them, but you can't object to them. So if you have a situation where you have a hearing that's kind of an emergency and a judge doesn't have availability, ask the coordinator and say, or the clerk, hey, can we get on the associate judge's docket? And I know right now, as she's kind of ramping up, she just started the beginning of this month, at the beginning of January, she still has time. And so, think about that as an option, and please don't be, sometimes people are really frightened or concerned or want to avoid going to the associate judge. There's no reason to do that, especially if the court assigns it to you.
Okay. Let me switch gears a little bit and go into our favorite things in the discovery process.
Mhm.
So, as I know I'm sure the vast bulk of issues are discovery issues that come before the court. First of all, that I'm just interested in, how do you get a feel for when someone is kind of obstructing the discovery process? Like as you kind of go through a case, are there any kind of like things that make you suspicious or concerned with how someone is approaching the process?
So there's a lot of things that wrap there. One of the things I would say is that I'm a judge, and sometimes people don't like this. I don't give out sanctions very often, especially if I feel it's just a good faith dispute. If you really feel like somebody is obstructing the process, then really document your efforts to get discovery done. So send them an email and say, hey, look, I'd like to talk to you about this. Give them a call and then follow up with an email and say, hey, I called you yesterday to try to talk to you about this discovery. You haven't responded. When can we talk about this? Send a letter to them and show that you've made every effort possible through email, through letter, and through phone call to try to reach out and try to work something out. And I had recently had a hearing where an attorney did an excellent job of really documenting everything he had done to try to get basic discovery out of the other side. That's the type of thing that maybe that's kind of how I was trained, but that is the most effective way if you ever do want to get sanctions or you do want to get more aggressive rulings from the court, is to show the efforts that you made. And sometimes people feel like I'm just going to send them an email. If they don't respond, that's a conference and I'm going to file it. And almost every time that occurs, what I'm going to do is send you into a breakout room or send you into the back room of the courtroom and confer, and you're almost certainly not going to get sanctions if that's your whole method of conference. And so those are, I was a litigator. I get, even though I've been a judge for 18 years, I get this dynamic and how frustrating it can be. To understand that I'm not there on a day-to-day basis. So you need to make every effort possible to try to work in good faith, and don't just do it to try to set the other side up. Do it because you honestly want to avoid being in front of a court. I mean, coming to a court to resolve a discovery dispute should be a last resort. It shouldn't be a first resort, and do everything possible to try to work something out. And if you really cannot do it and done everything you possibly can, then come to the court, and this court at least will take appropriate action to deal with that type of discovery issue.
That makes sense. I know for our firm, we really, really, really try to limit discovery issues to 3 or 4 really key issues. And so, that way we can get, solid rulings and we don't feel like we're wasting the court's time. How do you handle, when you get, pretty voluminous, compels and issues like that where people are fighting over stuff?
So, the first thing I'm going to do is really determine, have they really conferenced? If they haven't conferenced, then they're going to go back into the back room, or they're going to go into a breakout room, and they're going to really confer. Because really, again, going to a court should be your last resort, not your first resort. And so I'm going to make sure that they've really, truly conferred. But there are some cases, this just happens, where there's discovery issues that cannot be resolved. One of the things that I endeavor to do, and I've tried to do my 18 years on the bench, is try to be as consistent as possible in what my rulings are. I'm going to do, if I see X, I want to do Y, in every single case that I deal with this issue, because I think I need to treat everyone the same. And I want litigants to know that there's predictability in my court. And so, a perfect example of that is in almost every case, if you're talking about prior medicals involving a personal injury case, I'm going to allow 5 years, in the vast majority of cases, 5 years of prior treatment to the same area of the body that's being claimed in this accident. So if it's a neck injury, any treatment for 5 years prior to the accident is going to come in, as well as any treatment after the accident to that same area of the body you're treating, and so, or you're claiming in this case. I try to be as consistent as possible. I have some plaintiffs' lawyers who don't like that. I have some defense lawyers who don't like that. But what I tell them, and you probably, if you've been in my court, you probably heard me say this, I want to treat everyone the same. So I try to be as predictable as possible to try to limit these discovery disputes, because hopefully you'll know then, Judge Hoffman, I've seen him before, this is what he does. You can say, we don't need to bring this to the court. We know what they're going to do. But I do have situations where there is multiple, some people just can't work everything out for whatever reason. They try to confer, they won't confer. Sometimes one side or the other or both are being unreasonable. And I will do everything I can to try to rule on it. The likelihood that you're going to get to argue 100 different requests for productions in my court is virtually zero. What I will usually do is ask you to put together what I call a checklist order, which goes through each particular request. The ideal way to do that is have it part of the order. And I will either overrule or sustain the objections that have been made to the particular discovery request. And I can do them at this point of my career, usually fairly quickly. I may hear argument on one thing or another, but typically I'm not going to hear argument on it. I'm just going to go in the papers and rule as quickly as possible. So getting me a checklist order to rule on everything that I need to rule on will allow this to go a lot more quickly. If you don't provide me a checklist order, then I'm just going to make a ruling on the record by going through each of the individual discovery responses. It may take longer to get an order that way. So if you have a checklist order, that's the quickest,
efficient way.
The most efficient way to do it. And the ideal way, the best way I've seen it, is if you actually include the requests within. So interrogatory number 37 says this is the objection, grant, overrule, sustain, modify, and let me rule. And I can go through these usually fairly quickly. I don't know, that probably was more information than you wanted.
No. I think that's great. I mean, I feel like those are some practice tips that are exactly what people need to know when they're in your court. Okay, I'll go through a couple of them pretty quick here. How long do you give parties for voir dire?
So it depends. On a garden variety 1 to 2 day car wreck, I typically allow 30 minutes per side. If there's a reason to go more than 30 minutes, I may consider 45 minutes, occasionally an hour. My goal is always going to be to make sure voir dire can be completed in a day. So to get more than 2 hours per side, even on a big case, is pretty unlikely, because I want to be able to finish voir dire in a day. I do allow, I know this isn't exactly your question, but I do allow juror questionnaires on larger cases. My general approach, although I've done it different ways, is to allow the questionnaires, say the trial starts on Tuesday. If the parties want to, I allow them to do questionnaires on Tuesday and then come back on Wednesday. We may do hardships on Tuesday as well to try to get that issue dealt with. I have done this before in certain situations. I have a Monday hearing docket like we talked about. I maybe on Monday will bring in jurors for the questionnaire. Probably would not do hardships that day because I'm juggling my hearing docket at the same time and it's remote, and then come back on Tuesday for the oral voir dire. But none of this is set in stone. I've definitely had situations where I've allowed up to an hour on car wreck cases. On really big car wreck cases, maybe more than an hour. But just kind of generally, there is no hard and fast, but I will hold you to that. I know there's some courts who say you can take as much time as you want. That's not how I do it. Some courts who say you can only have 10 minutes. That's not how I do it. But my general approach is 30 minutes for a 1 to 2 day car wreck.
Okay. And then how about for openings and closings?
That really varies. On a one-day car wreck, I usually say 10 to 15 minutes. Again, open to discussion. Closings are typically 25 to 30 minutes on a 1 to 2 day car wreck. For every other type of case, it really varies. I would say for most cases, I'm not going to allow more than an hour for openings and more than 2 hours for closings. Uh, Unless there's something very, very unusual about the case. But again, it's just something that I wanted to discuss with the parties. I don't have any hard and fast rules on this. I just have general guidelines. And really, I think opening sometimes on car wreck cases, people don't spend enough time on opening. That can be on opening, and I have all sorts of theories about voir dire. I could spend hours on that, but on openings, this is your first chance to try to persuade the jury, come up with a theme, and don't try to rush through it. Sometimes people want to rush through their openings, have something prepared and come up with a theme and argue it. And you shouldn't. I've seen people do opening statements on some smart car wrecks that are less than 3 minutes long, and that is not very persuasive. That just seems like they're trying to rush through it. So, something to kind of think about.
Okay. How about how do you handle strikes for cause?
So what I do for strikes for cause, those who've been in my court know that I do kind of some interesting things there. So so I'm going to go through row by row with the jury. So you're going to have your chart. I'm going to ask each side, is there anybody you want to call back from the first row? Is there anyone you want to agree to strike for the first row? And I try to get people to reach an agreement on. Some jurors with just, act in good faith. They're clearly biased one way or the other. We should let them go. So we figure out who we're going to bring back. I also ask the jurors myself who has a hardship. We bring back all the hardships. If they have an English issue, we bring back all the English issues. And then one of the things I do on bigger cases, I may ask the parties to horse trade. And what I mean by that is, let's say there's a juror that's pretty bad for the plaintiff, and there's a juror who's pretty bad for the defendant. Why don't you agree to strike both of them? And then we don't have to bring them back, and it kind of speeds up the process. And I've seen attorneys use that very, very effectively and efficiently to get through, because we want to, at least the theory is, we want to have a jury that is fair to both sides. So if we can agree to strike certain jurors and not go through the whole process, I've seen that used very effectively. Don't be afraid of it. But to be fair to both sides. And I've done this for a long time. So I usually have a pretty good sense of who I think is a good plaintiff's juror, who's a good defense juror. I never mandate that. If people won't agree, they won't agree. But I have seen it used very effectively for both sides to get rid of jurors that probably neither side wants. And so, or one side or the other doesn't want. And it allows the process to go quicker.
All right. Well, one last question here, and then we'll wrap it up. I really appreciate all the time that you spent with me today. What are some basic practice tips that you would recommend for young plaintiffs' lawyers practicing in your court?
So one thing is, every case is important. I don't care if it's a small car wreck case. I don't care if it's a, multi-fatality death case. Every case is important. So if you're trying a small car wreck case, take it seriously. I mean, even if you're dealing with $5,000, $10,000 in medical and, difficult liability, you're starting to establish your reputation with me, but also starting to establish your skills and your reputation with opposing counsel and the defense bar. If people know that you're not really going to try your case, if you're not going to really give it your all, if you're not going to fight, then that's going to hurt every case you have after that. So every time you have a hearing, every time you have a trial, every time you have a deposition, always try to do your best and be as prepared as possible, because you are establishing the reputation you're going to have for the rest of your career. You may not have the best possible cases when you're a brand new plaintiff's lawyer. You're going to have cases that nobody else wants. I know that I did when I was a new lawyer, and I didn't always win. Sometimes you win, sometimes you lose. But doing your best and being as prepared as possible, and fighting the good fight in every single case, no matter how bad the case is. If you're going to take it to trial, you got to give it your all. And you may win, you may lose, but you got to dust yourself off and just keep going. And so that would be the advice I would give is you're establishing a reputation, establish the best reputation you can because it will continue with you for the rest of your life.
Oh, that's great. Well, I appreciate you so much, Judge. And we will get this out to the good members of the community soon. So thank you for your time today.
Thanks, Paul.